have an active presence on social media, Twitter and Facebook, and we call ourselves, it's hashtag jury, at Civil Jury Project, at Jury Matters. And we are all the time tweeting about jury service, and we're sending people to that website, We the People. So they go to the web, that's how we get the summon people to go to our website. This invitation, this is a card that we ask, and the judges who are here today, we ask you to be sure to pick some up when you leave, that we ask the judges to give to their jurors. As important as jury service is, there's no organized place in the country to go ask them, how did you like it? What can we do to improve it? I mean, you stay at a Holiday Inn, you're given a questionnaire. These people devote 3 or 4 weeks of their time, or even 5 days of their time, and there are some judges that will submit their own questionnaires, but not all of them. In fact, not many do it. We all trial lawyers know, in some jurisdictions you can talk to the jurors. In some jurisdictions you can talk to the jurors when the verdict is, after the verdict's returned. But that's a horrible time to talk to jurors. They're anxious to get home. You're standing there with the winning lawyer and the losing lawyer, and they don't want to talk. But the ones that are articulate, like some of the ones that you're going to see today, will go to this website and blog. And they are given a questionnaire. And if they're really good and we like them, we interview them. If they give us their name, they don't have to give us their name. We can do it totally anonymously. We will dispatch a videographer to go get a testimonial from them. And so that's the other website we use. And it works very good. So let me see. I want to now introduce, let me get to, yes. Today's focus of this program is going to be on how we can improve the affordability and reliability of jury trials. There are clearly alternative ways of resolving disputes, and we need to, but there's no way of exposing ordinary citizens to how the legal system works or empowering them to play an important role as decision makers. We did a study recently, which was, the results were surprising to all of us. We had some law students at a law school review every business-to-business contract filed by publicly held companies with an 8K at the SEC. Public companies have to file their material contracts. These are big contracts. And they're easy to get, they're readily available, and we reviewed over 5,000 of them in a 6-month period of time to see how many of those contracts had jury waiver clauses or mandatory arbitration clauses. To our great surprise, 53% did not opt out of the jury trial system. They had neither type of clause. So then we began contacting the general counsel of companies that we were able to identify, to ask them, so was this just an accident? Did you just forget? And amazingly, we identified a number of general counsel who will become, hopefully, spokesmen for jury trials that say they don't like arbitration. It's become way too expensive. Discovery is more expensive and more burdensome in arbitration. You can never get a matter disposed of as a matter of law because 3 judges who are making $750 an hour each are in no rush to get the case over, unlike a public judge. So, and there's no appellate review, and they think that juries are great and are willing to have their business disputes, at least between them, resolved by juries. So, and then we have, but there's still a group, the 43% of the people, of the companies, want to avoid jury trials. And so we asked, well, what can we do as lawyers and as judges for them to be better. Shorten the length. Let the juries ask questions. Improve the way we select juries. Improve the way we instruct juries. Improve when we instruct juries. Make judges can do this, doesn't involve jurors, but all of trial lawyers know the biggest expense and wasted expense of a jury trial is the constant resetting the case. Justice Gorsuch gave a speech the year before he went on the court last year, where he said 90% of the trials set in this country can continue. That's an unbelievable statistic. And no wonder people perceive, and repeat consumers of the system perceive, lawyers perceive, the trials are just have gotten too expensive because I've got to get ready 6 times. There's no setting that's real. And if it's real, I'll be dead before it's reached. So there's a great deal of, and judges have the power to do that. So now I'd like to introduce the judges who are here. And they are Chief Judge Patty Saris. Judge Saris is sitting right there. Good to see you. Judge Indira Talwani of the federal bench, sitting right there. We got all the judges sitting at the same table, which is
no, you don't.
unfortunate.
No, you don't.
But they all
I'm
came
in
late.
exile back there.
They all except Judge Laureate came late. So in any event, what we try to do with these things, and this, as I said, we perfect this as we go. And until we get together, we're never sure how many judges we will have and how many jurors. And now I would like for how many jurors do we have here? Do we have, I'll ask if Kristen Bedouin is here? She's not here. How about Maureen Canny? Well, then Mariel Del Rio, I bet, is here. She is here. And Bradley Tony? Okay, got 2 jurors. Hey, it's perfect. 2 jurors and 4 judges. So can I get them all now? And Judge Laureate's going to, a state court judge, will make a few remarks. Is Judge Young here? Richard, there he is. He's the guy who got me. You missed the, Bill, you missed the saying how happy I was to do this in Boston, because it all began in Boston, in your courtroom about 10 years ago. So the judges will come forward and the 2 jurors will come forward. We'll begin our panel discussion. And I'll ask them some questions. They can ask each other questions. And the idea is to find out what the jurors liked, what they disliked, and how we can improve it. So Judge Laureate and Judge Young, and can I get you to come up? And Judge Talwani, and can you come up too? Yes, both of you guys. Both of you ladies, yes. I'm sorry. And I have also Judge, is Judge Giles here?
Way back here.
Stay.
Back here.
Okay. Yes, Judge Giles, how are you? So we go. Good to see you. And, oh. Yeah, I got some jurors.
Tony, come up.
Yes, jurors can come up
Another juror in
too.
the back.
There should be room. Yes, Ms. Del Rio. Come up, please.
Ms. Del Rio's not here.
She is here. She's here. Miss Canny is not.
He's not here.
There's our chair.
Okay, there you go.
It's like, visible chairs on one of the ends.
And Peter, would you make some remarks? You can do it from here. You better, you.
I'll start by telling a story on Bill Young, because it was my introduction to one of the techniques I think a lot of us are using now, which is allowing jurors to ask questions of the witnesses during a trial. And my first experience with that was in 1985 when I was trying a criminal case in front of Judge Young. And right after the trial began, the first witness was on the witness stand, and I saw a juror hand a piece of paper to another juror. The piece of paper went down the row of jurors, crossed over through the U.S. Marshal to the clerk's desk. The clerk gave it to the judge. Judge Young opened it up, interrupted the witness on the witness stand, and apparently read from this piece of paper. And I had no idea what was going on. So I asked if, for a sidebar as soon as that was over, and said, I don't know what you just did, Judge, but if you're allowing the jurors, if you're allowing questions to be asked, I'd like at least the opportunity to object before the question is put to the witness. To which Judge Young's response was, I never ask objectionable questions. And it was going to be a long trial. It was a long trial. And my guy should be out soon. But it turned out, notwithstanding that, to be a great experience. And one of the things that shortly after that, beginning in 1997, a group of us in the state court system put together a project we called Innovative Jury Trial Techniques, the goal of which was to improve and enhance juror involvement, juror understanding, juror comprehension, and juror satisfaction with civil and criminal cases. And from that pilot project, we developed, I think a total of about 16 techniques, all of which have been tried elsewhere in the country. We first used them ourselves for a year to a year and a half. We surveyed lawyers, judges, and jurors about the techniques and about their response to the techniques. And all of the ones that the SJC ultimately allowed us to do, we presented in the form of a day-long fall jury trial court conference, where we introduced these techniques to judges around the Commonwealth and encourage them. We can't require them, but we encourage them to use any and all of the techniques they wish to. The ones that have lasted, I think, the longest and the best are things like allowing jurors to take notes, giving jurors notebooks of important exhibits and other information going to be presented during the trial, allowing jurors to ask questions through a procedure that has been established by the SJC, giving many openings during long trials in advance of, for example, experts taking the witness stand, putting the bookending the judge's instructions around the closing arguments. So the judge will instruct first on the issues in the case and then the closing arguments of the attorneys. So the jury has a context and a better understanding for those closing arguments, followed by the final instructions from the judge. Having the judge at least meet with the jurors at the end of the trial for kind of closure. The judge was the first one to meet with the jurors at the beginning of the trial, and the jury was selected. And the judge, in our view, can meet with the jurors at the end of the trial. I think most of us now do it. We ask for feedback from the jurors. We try to answer any questions we can answer from the jurors. We talk about juror stress and the need and ability to unwind at your own pace from especially a criminal trial, a serious criminal trial. And all of those have been very helpful and very useful. And we're about to launch a survey followed by, we hope, a couple of programs not celebrating, but recognizing the 20th anniversary of this project that we started in 1997 on jury trial techniques, to see who among our state court judges are now doing them, who's aware of them, who's interested in doing them. As we have new lawyers coming onto the bench, we're hoping that they use some of these techniques during their years as trial lawyers and will continue to use them as judges. So that's a bit of a synopsis about what we're doing on the state side. Steve? You can respond.
Yes. I agree with everything he said. Look, you know, I know most of you, and let's talk plain. There's a real irony here. All of you busy professionals have taken your time to come sit down. I didn't get any lunch. And talk about. there's a reason for that. Talk to my chief. All right. Now, Judge Gorton would be here, but she said, no, we're going. We said we were supposed to be there, so here we are. Now, look, and we're here concerned with how to improve the jury experience. And the irony is this. Steve and the people with whom he worked did everything he could to invite jurors. And we have 2. Maybe they had 4 names. Now we're down to 2 jurors. And I know that the panel will be most instructive based upon what they have to say. And yet the fact is that the jury, though they are constitutionally convened, they are direct democracy, speaking directly. They have powers that in the appropriate case, none of the judges, state or federal, have. We should recognize that. Those of you who go to court frequently, you do recognize it. It becomes pretty clear, pretty fast, that the jury's going to decide the case, not the judge. So, it really is up to us. You're the organized bar. You're the actual practitioners. And of course, in every particular case, you are doing everything you can within the rules on behalf of your clients. And so you should. But having said that, I am so encouraged that you have taken the time to be here and concern yourself with how we might improve the jury experience and improve that part of our constitutional democracy, which is direct democracy. The people themselves ruling directly. 3 quotes and I'll stop. The first, because I think you got it just right, is from Thomas Jefferson. Jefferson said, the jury is the greatest anchor humankind has ever devised for holding the government to the principles of its constitution. So it is. More recently, a judge said, where a jury sits, there burns the lamp of liberty. And I think President Reagan, got it right when he said, freedom is a fragile thing, never more than 1 generation from extinction. It must be fought for and defended in every generation, for it comes but once to a people. So if you want to know what justice is in the United States, justice, take a look. Oh, I respect and love them all, and I mean that from the bottom of my heart. My colleagues, both state and federal. If you want to know what justice is, look at those jurors. That's what justice is in the United States. Give them a hand.
Thank you very much, obviously, for coming. And I want to mention one thing before, because at 1:30 we meet sharply. I'll forget it if I don't mention. One of the things we do is this afternoon you will receive by email a survey about whether you want to repeat this lunch, whether you think it should be repeated, at what frequency, ideas for a program in the family, if you want to be on a planning committee. Because this is all local options. If the group in here thinks it's a good idea to do it again, the group in here is going to have to get themselves together and do it again. I've come to town once, I've shown you how to do it, but you know, it will be up to you. We'll take a survey and we'll distribute the results to everyone here. So you'll see what the vote is. That's a democracy too. Let me ask our jurors. Ms. Del Rio, were you on a federal or state court jury?
Federal.
And Mr. Tony? Federal jury. And okay, let me ask you a few questions. What kind of case were you in? Oh, I'm sorry. Guys, you gotta put your mics. Go turn on your mics, so turn green. Or we won't hear you. And I'm gonna be asking you some questions. Thank you. Okay. So you were on a criminal case?
Yes.
Yes.
And you were on a criminal case? So, let me ask you this. When you received your summons to report for jury duty, were you happy to get it or unhappy
Unhappy.
to get it? Unhappy.
Since it was federal, it said 15 days, which was very different from the state, and so I wasn't happy with that.
You were what?
It said 15 days you would be on call, so that's a lot of time. Whereas I'm familiar with the state, you show up one day, you're on or you're off. So it's easier to plan your life.
For a state, the way it is in state court,
It matters, yeah.
the number of days you have to be available. How long, were you on the same trial? Oh, you were both on the same trial. So not only, we have two juries, same trial, only in federal court and a criminal case. This is the civil jury project. But it illustrates, let me just show you a few more statistics, if I might, and I want to show the judges these today. Since 1962, you can see the red line is jury trial, the percentage of cases disposed of by jury trial. And the green line is the percentage of cases disposed of by bench trial. And that, of course, takes into account how many cases there are. If there are a lot of cases, you know, the percentage should be independent of the number of cases filed. But what you can see happening since 1962 is the lines have gone straight down to where at one point in time there was about almost 6%, 7% of the cases were disposed of by one type of trial or another. And now it's down below 1% for both bench and jury trials. And another important thing about this statistic is that the bench trials have fallen quicker than jury trials, which is the best rebuttal I can give to the notion that somehow jury trials are more expensive or dangerous. That does not explain the decline in the bench trials. The number of cases tried per authorized federal judgeship is down too in the same time period. So now the average federal judge tries 3 civil jury cases a year and has a bench trial of less than 1 case. This is the average federal judge. In the district court in Massachusetts, this is right here in Boston, the same pattern is there. This is the total number of jury trials which have fallen to around 30, just a little over 30 in 2016 from a high of over 100 in this district. The average federal judge here tries 2.5 per authorized judgeship. Bench trials are 5 bench trials, meaning the average judge did 0.4%. So it's not, it's not the most productive, or it's not the best or the worst. It's kind of the middle of the pack. And if you look, here are the numbers for we got the numbers for the Massachusetts Superior Court, and for the Suffolk County and for the state of Massachusetts. And these are only jury trials. We could not get the numbers for bench trials. But for jury trials, you'll see the same pattern exist. And so this is kind of why it's difficult to get jurors to come to these events. Let me ask, how long did your case last?
It was 4 weeks with 1 week of
4 weeks.
yeah, four weeks, but we have 1 week of vacation, I guess.
So, I mean,
3 weeks total.
Hmm?
A total of 3 weeks.
It went up for 3 weeks, and 1 week was off.
Right, so a total of just over a month, right?
Did you think the trial went on too long?
No, for me, because it was predicted to be twice that long.
What do you think is a single thing, Mr. Del Rio, that we can do to improve trial? What would you like to see? Do you want to do it again?
I'll take a break for 3 years and then I can do it again.
And what can we do to improve trial?
I think the summons is very scary for most people. Everybody at work had pity on me, like, oh, too bad, how did this happen to you? Like if it was a very bad thing. If you read the little note on the bottom, it says that you can go to jail for 3 days and get community service or $1,000 or $3 of them $1,000 fee if you don't present. So it comes like a threat to the general public, to the simple people like me or him. It's like, oh, I don't have $1,000, I better go. So I think we could improve it by maybe the letter could be a little more motivational, not showing you the punishment, but all the rewards that you will have by participating in a jury.
Okay. Tony, what would you do?
As I mentioned, for the federal, to be on call for so many days, and I know there are other trials that are many months, but that's hard to put into your life. And I'm retired, so it was fairly simple, but very difficult for other people.
You sat there as retired,
Right.
and
I am a part-time worker right now, so it was not too difficult.
were most of the people on your jury who were able to hang around for a month retired or part-time, or
No?
No, they all had full-time jobs.
Right.
they all had full-time? Did, in this district, in the federal courts, how much do you get paid a day?
$10 an hour, I think $40 a day. Went up to $50 a day after
this year.
October 1st. I think
$40 a day,
went up to $50 a day for 4 hours.
okay? Would it have helped if there were some resources available to you to increase your pay?
Yeah, definitely, yes.
I don't know if it would make much difference. Most people, I think all the people, were able to work something out with their employers. And I know when I was working, it was in the contract. If you were on jury duty, the organization was going to pay. And most of the people said there wasn't a limit on that.
In federal court, whose court were you in? Were you Judge Young's court? This is even horrible. So the best judge with jurors brings 2 jurors. But thankfully, he did bring 2 jurors. So you're not going to have anything critical to say. I'm barking up the wrong tree here. Let me ask you some questions. In his court, I don't know the judge now. When you were selected, did he do all the questioning, or did he allow the lawyers to ask questions?
No, the lawyers made most of the questions.
The lawyers could ask questions.
Oh, you're talking about the selection process for the jury?
Before you were selected, it's the jury selection process where there were many people in the courtroom. How did it work?
Okay, basically, we presented and he asked the questions, Judge Young.
He asked the question.
But that was after we did a many-page survey. And then,
You had a questionnaire.
right. And then there were, I think, 2 working days. I assume they were working that out. And then we called, and most of us came back, and then we went to court
Okay.
after the many-page survey.
The survey, were you offended at having to answer the question? Do you think it invaded your privacy in some way?
No.
You didn't have any problem with it?
No.
So one of the innovations that's suggested is the submission of lengthy questionnaires, and not only were they submitted to you in advance, you filled them out at home, or did you come to the courthouse to do it?
There was one that we filled at home, could be done online, and then there was a longer one that
the
was
courthouse.
at the court.
And then you went away for 2 days.
Yeah, I believe 1 or 2 days.
And Judge, how long did you have lawyers with those questionnaires?
That was the 2 days.
That was the 2 days.
That's it, just right.
So a lot of judges now are using questionnaires. All these innovations are not new. They're also, what happened on the innovation scene is that in the early 90s, the state courts in Arizona were very innovative A lot of these things were tried, and by the end of the 90s, the other state courts began picking it up. Apparently Massachusetts picked it up in 98. Judge Moore had suggested that's when they had some project and survey. By 2005, the ABA, the American College of Trial Lawyers, was recommending all these innovations. And one of the questions I want to ask the judges, why, Judge Laureate, let me try you. In fact, the studies have been done, and there's been a very slow adoption rate of these innovations that are now 15 years, have been around for 15 years, suggested that it be done. Why are judges so slow to do these things? In Boston, in Massachusetts, did it require some change in law? Or did you have the power to do them without a change in law?
We had the power to do almost all of the changes that we suggested. The only one that we could not do in the end was allow the jurors to discuss the evidence during the trial, whenever they were on break, which is an Arizona practice. In fact, it's mandated in Arizona that it be done, at least in Maricopa County. One of our judges, as part of our project, did that, and it was not well received by the FJC. I think in part because he didn't ask the lawyers if they agreed. He just went ahead and did it. And that we then dropped, at least for the foreseeable future. But the other practices we all felt we could do. There were a couple of cases from the SJC, for example, allowing and describing how jurors could ask questions and what kinds of cases. Juror note-taking, juror notebooks, a lot of good language from our SJC judges saying anything we can do in this day and age to help jurors. For example, if the judge wanted to come down and give his instructions or her instructions to the jury on a PowerPoint presentation at the end of the trial, perfectly acceptable. Using a chalkboard was acceptable. Using hard copies of jury instructions and giving them to the jurors at the end of the trial so they'd have a much better chance to understand. The instructions was acceptable. Tape recording the jury instructions was acceptable. Part of our project in 1997 was to see whether there would be a difference in the number of questions asked by jurors during their deliberations if we gave them either taped or hard copies of jury instructions as opposed to simply reading them or speaking them to the jury and telling them to go deliberate. And the number of questions went down from 6 to 0.5 per trial. It was a tremendous help, and all of our feedback from the jurors was that they felt much better sitting down and being able to read and hear and understand our instructions, if necessary, again and again, to ensure that they got it right.
So, do all the judges allow questions, jurors to submit questions to the witness? Do you, Judge
No.
Severs?
Yes and no. I
What's the
absolutely do in civil, particularly very complex civil cases like, say, patents or product liability. And I just think it's very hard to understand, and I actually encourage, and I sort of almost admonish them, no one's asking a question, don't be shy, to make sure they understand the scientific evidence. I feel very differently about criminal trials. I think that what I do is not allow the jurors to ask directly to witnesses. I ask them to send it through me, just to make sure that there's nothing inappropriate that could taint the whole process. But can I just give you a little pushback on something?
Sure.
The questionnaire. I think the questionnaire, I think it's really hard to be a juror. Let me just say that. You're coming out of your ordinary, everyday life, you've given up your job, and in the ordinary mine-run case, a questionnaire takes a lot of time and is not necessary. It's the extraordinary case, let's say a death case, or maybe something where there's a huge amount of racial implications, where it might, or a child pornography case. Perhaps you might want to ask a question or two, but when you ask these lengthy questionnaires, it's for, and I think I know which trial you were on, it would be for an unusual trial. And I do not believe it is the practice in our court to do that as a routine matter. And so, let's say some of the questionnaires that I've seen might ask you, what magazines do you read? What church do you belong to? What are your beliefs on drugs, etc.? Which start getting very personal. And I jury, you have no right but to, you have to answer these questions, except in the compelling case. And I'm sure that this was, I think I know which one it was, I think this was that kind of case.
Judge Trelawney, do you use questionnaire? Well, let's do you let the jurors ask questions or
So-
submit questions?
So,
Civil case,
I haven't yet.
haven't yet.
And I have to say, so I'm 3.5 years on the bench, so a much shorter run than anyone else. So I still have pretty fresh in my mind my experience from being a lawyer. And I think the notion that I share your sort of immediate reaction of the notion that the judge is just popping out the question feels a little bit concerning to me still, but,
Do you let, in a civil case, do you allow lawyers to ask, participate in the voir dire at all?
Yes.
You do?
But
Limited?
Limited, so in general, they give me questions in advance, I tell them which ones I'm gonna ask, I bring the jurors up and I ask them. And then if an attorney says, can I follow up on that, judge, I say, fine, follow up on it, but I'm controlling it. And I have to say as background, for example, in a recent drug case, literally, 1/3 of the jury came up and started telling me about problems they or their child or someone they were close friends with had with drug addiction. On a child porn case, you would be shocked at how many times someone comes up with tears in their eyes and says, I've never told anyone this, but I've had a personal experience where I cannot sit on this jury. I mean, those are the kinds of sensitive things that you hear. Not so often in the civil side, I have to say, but certainly on the criminal side, you hear personal stuff where I just feel as if a full-blown individual voir dire from a lawyer maybe isn't the best starting point.
And in your case, were you allowed to ask questions of Judge Young before? How did he work? Did you like the ability to ask questions?
There weren't many, but they were submitted to him.
In writing?
Yes, in writing. By
And
the four person.
do you think it was a distraction to you? In any way?
But they were minimal.
Didn't bother you?
Like only 2 or 3
Most, I mean, the practice of letting the jurors ask questions is the one that's become the most popular. And that, in a civil case, it's not, you don't ask them orally. They write the question out on a piece of paper, each of them has 12 jurors, if there were 12 jurors on a case. Each of them passes a paper to the bailiff, bailiff collects a paper. Maybe there'll be no questions, they'll all be blanks. But maybe on 1 or 2, a piece of paper, there'll be a question. That the judge looks at, he calls the lawyers to the bench, shows the lawyer the question. I mean, I've done it, I think it's fantastic. I love to do it. It lets you know what the jury's thinking, kind of, where you need to focus your attention. And the jurors who we questioned about the practice afterwards said, yeah, I thought it was great to be able to do that, and it kept me kind of engaged, awake. So that's, I mean, someone say that about the practice of asking questions. And let me ask the judges then, in a civil case, limit yourself to a civil case. If I can get the lawyer on the other side to agree to do something, whether it be ask questions, make interim arguments, whatever, use a questionnaire, in what circumstances would you agree to let the lawyer to do it if the lawyers have agreed to do it? When would you say, no, I'm not going to let you do that anyway? I'll give you a better example, one that I'm confronting right now in a case. I've got this big case set for trial, and the judge's standard pretrial order that we are required to complete requires that, like in 60 days, I mean, it's like 60 days before the trial, you've got to list your deposition designations. Designating deposition testimony is the biggest court project known to the organized trial bar. I mean, it is a total waste of time because 95% of what you have paid associates by the hour after hour to go designate, never gets read anyway. So I try to get the other lawyer to agree that we will do kind of a just-in-time designation, 48 or 72 hours before we're going to play testimony. Once that was designated, the other side is counter, and we show it to the judge if there's any objection, and then we do it. So there's this argument we are having now about whether the judge will let us get away with it. We don't know whether the judge will let us do it or not, but there's an example of a practice that I think makes exchanging deposition designations no good sense. Most good lawyers will agree to dispense with it. And yet, okay, are the judges going to let us do this or not? Judge?
No.
Ms. Sars? No?
Because
Listen,
my favorite expression is, I'm not an ATM machine. And what I mean by that is, you have the designation, you have the counter designation, you have the objection. I get it the day before, and I've often get 52 objections.
Right.
So I'm not gonna be there till midnight or 2 in the morning ruling on objections and hearing arguments. So I don't know the 60 days, I mean, that may be longer than is necessary, but you've got to at least give the judge enough time to have a reasonable period of time, so the judge isn't up till 2 in the morning.
Right, or if it's a video deposition, that they're asking to do this at the 11th hour with all of the objections, and you're then up till 2 in the morning, they're there struggling the next day to splice the thing to comply. I mean, it's a disaster doing it in no time.
do you have video deposition testimony in a criminal case or not?
No.
Well, we did,
No,
we
you
did
don't.
in Nancy's case with the Japanese, the criminal antitrust case. She had some from
It's rare.
overseas, but very, very rare.
So, deposition, let me ask you this one.
So wait,
Deposition,
wait, just ask, so come up with a reasonable period of time for the judge to rule.
well, I'll ask you what that would be normally.
How many objections are there?
Well, you know what?
If you work
You
it out,
tell, excuse me, you tell the lawyer you can use this procedure, but you can only have one objection per 20 pages of deposition. Make it some arbitrary time. I mean, say you can use it, but you can't.
Would you agree to that? If someone,
Absolutely.
if a judge said to you, one objection and 20
Ab-
pages of depo?
Absolutely, because deposition testimony is wasted anyway. It's nonsense. It's ridiculous. No one wants to. How quick? You know, the problem is now, in lawyers like me, I'm just learning. It's taking a hard time. I'm learning from my grandchildren. That the average juror's attention span is about 3 minutes or 5 minutes. And we have to learn how to do things in a different way. They can't sit there and watch 15 minutes of deposition testimony, nor could I. And I'm not a millennial, but it's very difficult to concentrate. And so one of the things that I heard a lawyer just explain to me, a very little trial lawyer in Houston, explained to me that when he takes depositions, he has 2 cameras. One camera is on the witness and one camera is on the lawyer. Because it really is deadly when you just watch the witness, the talking head. And people are used to going to movies where, watching on TV, you see the lawyer ask a question, and then the camera goes to the witness with the response. So, there's nothing in the federal rules that answers this question for me. But I am going to show up with at my desk, federal deposition, with a videographer that has 2 cameras. One camera will go on me asking the question, and one camera will go on the witness. I suspect for the lawyer on the other side is going to object. And it'll come. We need to think about something. How can we make it more entertaining for jurors than we currently have? Would you allow 2 cameras? Isn't the objective to make the video a video deposition as close as it can be to courtroom testimony?
Oh, I allow it, but of course I trash you in the sense that when you started to play, I'd say, all right, now on this, you're gonna see the lawyer ask the question, you're gonna see the witness answer. Keep in mind that it's the testimony of the witness, that's the testimony here. Not what the lawyer says, not what the lawyer assumes, et cetera. And if I thought that we were going overboard, I'd say, hold it, and then I would instruct further. But I tend to allow it. I do want to get in on this business about the objections. I'm with my two colleagues on this. Just because you agree, I'm not taking a whole mass of objections on the eve of playing a video deposition. It makes no sense. But, oh, I'd allow that. Why not?
Okay, well, I mean, there are things that we can, all I'm saying is, why aren't these things adopted more frequently? One reason is that it's very difficult to get lawyers in the heat of battle to agree on something. Because the first reaction is, if Sussman's asking for it, it can't be good for me. That's the first reaction. It's always gotta be, if the other lawyers wants this, there's something up here, even though it makes totally good sense. Like interim arguments. Have you ever allowed interim arguments?
Yes.
Have you allowed a judge to tell one?
I haven't been requested, haven't had it requested.
Just SARS? Where the lawyers are given part of the opening statement, they are allowed to,
The only thing that I've done once, it's almost never asked for, although I'd be open to it, is in a very complicated case involving experts. I think I once allowed, when they agreed, both attorneys to explain what the scientific dispute was and what they would be hearing. I think I once allowed that by agreement, but not like I'm just on certainly never in a criminal case. And
But where the example that comes immediately to my mind is a patent case.
yes.
And you're trying invalidity and infringement. So my usual procedure is to require that you put in all your evidence of invalidity first, both sides. But of course, you're going to keep the jury throughout the case. You're not going to bifurcate it because then you'd never get to infringement. So I'd let them take some brief because they want to get back to it in their real closing. But I'd let them wind up once we've heard invalidity. Then we go to infringement, which is a different set of issues.
I
Yes,
was just
Judge.
going to respond to sort of the general notion of if lawyers have an idea that they want to do something, and how do you deal with this pretrial order that comes way in advance. And I would say that there are two sorts of things. And the one is where makes no difference to me, frankly. And if that's something that you can agree on, I don't see any reason why I wouldn't let it happen. And then there's another where it does make a difference to me. But I think part of the problem is how does that get presented to the court? And one thing I try and make clear is sort of open communication through my courtroom deputy with emails to the other side. So they're not one-sided things, but there's also a slightly more informal way, and then she can go back to them and say, do this by motion, or we'll get you in for a telephone conference or something, but some way that they can tee up, we have a question about whether we could do something.
Yeah, I think one of the reasons, by the way, of the slow adoption of these changes that have been recommended for many years is that the judges and the lawyers are not communicating openly and freely. And I would encourage the judges to encourage the lawyers to reach agreements, to discuss things, how we can make the trial quicker and better and more informative. Because if you don't do it, the lawyers aren't going to, give you an example. Here's an example. The simplest thing in the world to do is to number exhibits 1, 2, 3, 4, 5, 6, 7, without regard to plaintiffs or defendants or Jones deposition exhibit 1. To agree with the other side at the very beginning, that's the way we're going to number exhibits. And when we come to trial, we use the same number. So you don't have to renumber if you're playing video depositions. That's a simple thing that I can almost get every opposing counsel to agree to.
I can't get them to follow my order to do that. I mean, you would think it's the simplest
That's
thing,
your
and it's
order.
yes, and it's
Okay.
amazing how the default is to mark them as mine and mark them as yours. I don't know why I make them redo it.
Because lawyers like me have gone in and the first person we confront at the courtroom door is the clerk. a deputy who's been a courtroom clerk long before you were there, and says, no, the judge doesn't want to do things that way. The judge wants it marked plaintiffs and defendants. So even though I've got agreement of the other side that we're going to do this in a sensible way, we are stopped by one of your staff members. And I don't think it ever goes to you. It stops with a staff member. So
Can I just say, the single biggest complaint I get from juries, I love my juries, we feed them, you know, we thank them, we treat them really well. I used to be a state court judge, I think the same would be said on the state court level. I mean, to us, it's just a.
You can't afford to feed them, though.
I feed them, come on over. So, it was so repetitive. Why did it have to take so long? They kept asking the same questions, and they, you know, like, we're not stupid. You know, like, why did it have to take so long? Or if God forbid, now I started instituting time clocks in civil cases, not in criminal, but I do it on civil cases, because you're making a covenant with this jury. It's going to be done in 2 weeks, and then suddenly it morphs into a third week. They have lives to return to their job or their kids or whatever it is. So I do think that's a burden that should go back on the attorneys, which is, one, when you say it's going to be a certain period of time, it should be that period of time. And second is, you don't have to ask the same thing 17 different times. It should be crisp. And I know there's always the fear, oh, you haven't made the record for the appellate court. I get that. But the reality is that's what the jury's thinking, and they're sort of marking you down if you keep asking the same thing again and again and again. So that would, if I don't know if you all felt that way in your trials, but.
was there a lot of repetition?
At times, not most of the time.
Well, one
Some
of
of
the,
the time.
sorry, one of the side benefits of allowing jurors to ask questions is that during the trial, they will often raise that very issue. And you get the benefit of reading at the side of the bench to the lawyers, a question for a juror like, why are the lawyers treating us like children? Why are they repeating and repeating and repeating what we've already heard? And sometimes the lawyers get the hint, sometimes they don't, but at least you've given the jury the opportunity to vent their frustrations. I've also, on one occasion, when we had 6 experts in a medical malpractice case, when the 5th expert was asked what it means to be board certified, I turned to the jury and said, if anyone doesn't know what it means to be board certified, raise your hand. And none of the jurors raised their hands, so we moved on. That kind of repetition especially is unnecessary.
Let me ask the two of you, when you went to deliberate, did you have instructions on the law at the beginning of the case? Did Judge Young give you any instructions?
Yes.
At the end? Did you find that helpful to get?
Yes.
At the beginning of the case? And at the end, did you each have a copy of the instructions, or was only one copy sent back?
I was an alternate, so I didn't get to deliberate.
You didn't go to deliberate, but you went to
Yes.
deliberate.
Yes, and he gave a presentation in court, and before the summation, and that was useful. But then, I don't remember whether he said he would send it or we asked for it,
How
but
long
shortly
did you-
after we went in deliberations, we had it in writing, and it
How
was
long did
very
it take you
helpful.
to reach verdict?
I counted because I worked waiting
Oh.
outside, 9 hours.
A day and a half.
It was during 2 days, 9 hours total.
Right.
So, and how did you select the foreman? Did you select the foreman or did the judge select it? The judge selected the foreman. How did you select the foreman, Your Honor?
I always select, I have this protocol. When it works out, whoever is in the 4-person seat in terms of gender, I look for someone of that gender who I think will be a good discussion facilitator. It has nothing to do with education, a shop foreman, a receptionist, a bartender, an executive, a housewife, all, and I know this is hardly an exact science, but I'm looking for someone who I think will be a good discussion facilitator. And I'm looking as their pick. If a minority is in that seat, that's it. It's state action. I would never move a minority and replace them with a non-minority without regard to
Okay, Judge, could I, since I'm no longer, haven't been in court in 10 years, I feel free to ask questions on this. A lot of empirical studies show that the verdict matches with the foreman's opinion. But the foreman has an oversized impact on what happens with the ultimate verdict. And so by your taking on your own, selecting a foreman, don't you, if that research is any good, aren't you worried about pushing the result one way or the other?
No,
Not,
it's not that I haven't thought about that. And the way I attempt to deal with that is, in my charge, I discuss the deliberations, and I say that the foreperson does not do all the talking, nor does, in our case, she keep her mouth shut. Everyone should deliberate together, and then I go on.
how quickly after you began your deliberation, when did you take the first vote?
Oh, wait a minute.
No,
Wait a
no,
minute.
no.
Okay, that's a question.
No, you can't, not since I brought
Okay.
these people here.
Okay. So this is a problem.
If I didn't know anyone here, maybe we would, but not as manager.
Let me, we are about out of time, and in fact, we are out of time. I told people we'd finish at 1:30, so, but let me thank you all for coming and tell you what would make a phenomenal program that you should give to this, the bar in this community. If you can find a complex civil case, that lasts for a couple of weeks with real, and good lawyers on both sides, that settles after a verdict is returned, please email me immediately, because that would in and of itself create a great program, because then you can get almost all the jurors to come. They'd love to come and talk about it. The lawyers will come, and the judge will come. And there's no problem of asking what, I think at that time, if it's the case is settled, people can ask whatever questions they want, and we can find out more information. So, I think, am I right, Judge? I mean,
Oh, absolutely.
at that point. So that, but let us know if any of you know of such a case, any of the judges here or anyone else here, because that makes a phenomenal program. And the other thing we learned doing these things is that if you get to the jurors after a few weeks, after the trial ends, or 3 weeks, they pretty much forget everything, but whether the cookies were any good or the parking was terrible. I mean, they remember that, but actual help in improving the process is difficult for people to remember. Thank you very much for coming. I appreciate it, judges. Thank you.